Welcome back to the Deep Dive. Today, we are going to completely shift your perspective on something you probably see every day but never really think about.
Mm.
We're stripping away the steel, the concrete, all the heavy machinery of these huge infrastructure projects to look at the engine room.
But not the generators.
Not the generators, I mean the people.
Yeah, it's the part of the project that usually causes the biggest headaches, the biggest delays, and, frankly, the biggest lawsuits.
Exactly.
It's one of those topics that seems so rigid on the surface. I mean, contracts usually are. But when you peel back the layers, it's really a story about human behavior and whisk.
Right. When we think construction contracts, we just imagine blueprints and budgets. But today, we're ignoring all of that. We're focusing entirely on the human element.
The thousands of people you need to actually build these things, which is often the most volatile part of any project.
So we're looking at a specific set of rules that governs their lives, their safety, even their rest days.
And our source material for this is the absolute gold standard. We're looking at the FIDIC Red Book, the 2017 edition. Specifically, we're doing a forensic analysis of Clause 6.
Staff and labor.
That's the one.
Now, for anyone thinking Clause 6, that sounds like HR paperwork, I have to stop you right there. As I was reading this, I realized this document basically turns a construction company into a sovereign state.
That is a great way to put it. EPIA is the International Federation of Consulting Engineers, and, this contract is used all over the world. So our mission today is to uncover how this legal text really dictates the reality on the ground.
Right.
It's not just about getting the job done. It's about managing a temporary city.
We're talking about everything from preventing riots and managing epidemics to poaching employees and the absolute power of the safety officer.
So let's get into the weeds.
Let's do it. So I want to start with the ecosystem itself. Clause 6.1, it sets the stage, and it basically says the contractor isn't just an employer.
No, they're a provider.
A provider.
Right, unless the specification, that's the detailed project description. Unless that says otherwise, the contractor is on the hook for everything. The text says they have to arrange for the engagement of all their personnel.
Okay, that makes sense.
But then it lists payment, accommodation, feeding, transport, and welfare.
Feeding and transport. See, that destroys the whole assumption that you just need to pay people.
It does.
I mean, in a domestic project, say building a condo in New York, the workers go home at night. They buy their own lunch.
Precisely. In the FEA context, which is often for massive projects in remote locations, that assumption is just dangerous. If you bid on a project thinking you just need to pay wages, you'll go bankrupt.
Wow.
You are legally required to figure out how 3,000 people get to the site, what they eat, and where they sleep.
So if the bus breaks down or, I don't know, the kitchen catches fire,
Yeah.
that's not just bad luck.
It's a breach of contract.
Yeah.
It is. It shifts the burden of, basic life necessities onto the contractor. If the workers are hungry, the project stops, and legally, it is your fault.
That leads us straight to the money. Clause 6.2, rates of wages. Now, surely this just says, pay the minimum wage, right?
You'd think so, but it's actually much more nuanced and, frankly, more protectionist than that. It's designed to prevent exploitation, yes, but also to stop market disruption.
Okay.
The clause says wages have to comply with the law, obviously, but they also can't be lower than those established for the trade or industry where the work is carried out.
So you have to pay the going rate, no lowballing.
Exactly. But here's where it gets really interesting and where a lot of contractors get trapped. What if you're building a dam in a remote area where there is no established trade rate?
Right. What's the benchmark then?
The contract covers that. It says if no established rates exist, you have to pay wages that are not lower than the general level of wages, observed locally by employers whose trade or industry is similar.
Ah, I see what they're doing. They're stopping a massive international contractor from coming in and just destroying the local economy.
Exactly. Imagine a global company comes into a small rural area and decides to pay triple the local rate. They'd drain every other local business of staff.
It would cause chaos.
And conversely, it stops them from undercutting the local standard and exploiting cheap labor just because there isn't a union.
So it forces you to integrate, not dominate.
Right. And speaking of dominating the market, we have to talk about Clause 6.3. I called this one the poaching ceasefire.
This one stood out to me because it feels very, gentlemanly. It's a reciprocity clause.
It's a demilitarized zone for HR. It says the contractor shall not recruit or even attempt to recruit staff from the employer's personnel.
So the construction company can't try to hire the client's own engineers. But it goes both ways, doesn't it?
It does. The employer and the engineer can't try to recruit the contractor staff either.
So why, I mean, in the tech world, poaching is like you get a raise. Why is construction different?
Think about the leverage. You're in the middle of a critical concrete pour on a bridge. The client knows your lead superintendent is the only person who really understands the geometry.
Right.
If the client could offer him a 20% raise to switch sides mid-project,
They could hold the contractor hostage. It would paralyze everything.
you'd have a bidding war for talent right when you need stability. This clause just freezes the rosters.
Everyone stays in their lane. Okay, moving on. Clause 6.4, labor laws. This basically says the contractor has to be a legal shield.
Yes, they have to ensure all their people comply with applicable laws. But look at the list of what that includes: health, safety, welfare, immigration, and emigration.
Immigration and emigration, that's huge for international projects.
Huge. It means if a worker's visa expires, or if they have the wrong paperwork, that is the contractor's contractual problem, not just a legal one.
So you have to be a migration agency as well.
Effectively, yes. Which brings us to a specific legal right word, the contract safeguards, which I found fascinating. The rest day, clause 6.5.
This is a strict one. It explicitly says when you cannot work. No work shall be carried out on the site on locally recognized days of rest.
This is where cultural intelligence becomes a legal requirement. If you're in a country where Friday is the holy day, you don't work Friday. You can't just power through because you're behind schedule.
And you also can't work outside the normal working hours. So no deciding to run a 24-hour shift just to catch up.
Unless
There are always exceptions.
there are three. First, if the contract says you can. Second, if the engineer gives consent. So you can ask.
And the third one is the dramatic one.
The emergency clause. Work is allowed if it is unavoidable or necessary for the protection of life or property or for the safety of the works.
So a tropical storm is coming, you need to secure the cranes.
You act. You don't need to fill out a form. But there's a process. The clause says the contractor must immediately give a notice to the engineer with reasons.
So you can break the curfew, but you have to explain why. Immediately.
Exactly. It's a break glass in case of emergency tool, not a scheduling tool.
Right. Now let's talk living conditions. Clause 6.6, which creates the mini-city.
Facilities for staff and labor. The contractor has to provide and maintain accommodation. But there is a very specific gotcha here.
The location.
Oh, this is a trap for the unwary. Housing must be located within areas specifically identified in the contract unless you have prior permission.
So you can't just set up camp wherever it's convenient, say slightly off-site, because the ground is flatter.
If you do that, the contract is brutal. It says if facilities are found elsewhere, the contractor shall immediately remove them at the contractor's risk and cost.
Ouch. Imagine building a dorm for 500 workers, plumbing, electricity, and then being told, move it, and you're paying.
It's a project-killing expense, which is closely tied to health. Clause 6.7, health and safety. This goes way beyond hard hats.
Way beyond.
It requires collaboration with local health authorities.
Yeah.
It mandates medical staff, first aid, a sick bay, and ambulance services are available at all times.
At all times, and not just at the work site.
But at the accommodation, too. If a worker has a heart attack in the dorms at 2 a.m., the contractor is contractually obligated to have a system in place.
You are the emergency services for your workforce.
You are
And then there's the word that we all pay a lot more attention to these days.
epidemics.
Clause 6.7b. The contractor has to make arrangements for hygiene requirements and for the prevention of epidemics.
Before 2020, people probably glossed over that. Now that is the scariest sentence in the book.
It puts the entire burden of public health directly on the builder. Quarantine, sanitation, testing.
It all falls under this clause. It's basically saying if a plague breaks out in your camp, it's your job to stop it.
Which means the project manager is effectively the director of the CDC for that site.
Pretty much. And to enforce all this, the clause mandates a health and safety officer. But listen to how this role is described. It's not just a box-ticking thing.
The source text says this person has to have the authority to issue directives.
Exactly. And to take protective measures to prevent accidents. The key phrase is, the contractor shall provide whatever is required by this person to exercise this responsibility.
Whatever is required. That sounds like a blank check.
It basically is. The safety officer can technically outrank the project manager on safety issues. If the officer says, I need $10,000 of new ventilation equipment now, or I'm shutting this tunnel down.
The project manager can't say it's not in the budget.
Legally, no. Because if they refuse, They're breaching Clause 6.7. The contract empowers the safety officer to override commercial pressures.
That's a powerful dynamic. Okay, let's move to command and control. Who's actually running this ship? Clause 6.8, contractor superintendents.
This says you can't just hire a bunch of workers and leave them to it. You need supervision from start to finish.
But there's a specific requirement for the supervisors that I found really interesting. It's about language.
This is a critical detail. The clause says superintendents must be given by people who are fluent in or have adequate knowledge of the language for communications.
Which is defined way back in Clause 1.4.
Right. If the contract says the language is English, your supervisors have to speak English. But it goes further. They also have to know the operations and the hazards.
So you can't just have a translator who doesn't understand construction.
Exactly. Or a genius engineer who can't speak the language of the site. If the superintendent sees a wall about to fall and yells, "Run!" in a language nobody understands, they are not fulfilling Clause 6.8.
It links fluency directly to safety. Okay, that leads us to the VIPs of the site. Clause 6.11, key personnel.
These are the people named in your bid, the project director, the lead engineer. The contract treats them differently. They're essentially locked in.
You can't just swap them out.
No. You can't revoke their appointment or appoint a replacement without the engineer's prior consent.
Why is that?
Because the client hired you based on the team you promised. If you say you have a world-class bridge builder, and then on day one you swap them for a junior.
That's a bait and switch.
It is.
Yeah.
But there's a tactical loophole for the contractor here. There's a 14-day clock. If the contractor proposes a replacement, and the engineer doesn't object within 14 days, consent is deemed to have been given.
Deemed to have been given. So silence is approval. I love that.
It keeps the project moving. You can't just hold things up by ignoring an email.
And there's one more rule about them. They have to actually be there.
Yes, based at the site. If they take a vacation, a suitable replacement must be appointed. You can't manage a mega project via Zoom.
Okay, we're into the final stretch. We've talked about hiring, housing, health. Now the ugly part. Firing or removal. Clause 6.9 gives the engineer some pretty scary power.
The power to remove. The engineer can require the contractor to remove any person employed on the site.
Any person. Even the contractor's own staff.
Yes. If they persist in misconduct, are incompetent or negligent, the client has a veto over your workforce.
But there are two other grounds for removal that are really fascinating. One is corruption.
Yes. If someone is found, based on reasonable evidence, to have engaged in corrupt or fraudulent practice, they are gone.
And the other one? This felt very modern to me.
Clause 6.9d. You can be removed if you persist in conduct which is prejudicial to safety, health, or the protection of the environment.
Protection of the environment. So if a worker keeps dumping oil into a river, the engineer can force the contractor to fire them off the site.
Absolutely. It links individual behavior directly to environmental compliance.
And finally, Clause 6.01, disorderly conduct.
This is the peacekeeping clause. The contractor has to take precautions to prevent unlawful, riotous, or disorderly conduct.
Riotous. That is a heavy word for a business contract.
It is. But remember, you might have 5,000 workers living in a remote camp miles from home, doing hard labor. Tensions flare.
So the contractor is responsible for preserving peace and protection of persons and property.
They're the police force, too, in a way. If a riot starts, the contractor is liable for not taking necessary precautions.
So let's step back. We started by saying this was about staff and labor, but after all this, it feels like so much more.
If you synthesize all of this, you realize that while it's a construction contract, Clause 6 demands that the contractor function as a government, a hospital, a police force, a housing authority.
And a migration office, all at once.
Exactly. They aren't just building a dam, they are running a society.
A temporary society, bound by these incredibly specific rules.
Every meal, every ambulance ride, every rest day, it's all codified here. It's a tremendous amount of liability disguised as HR paperwork.
So, for you listening, the next time you drive past a massive construction site, don't just look at the cranes. Think about the mini-city inside those fences. Realize that there's this complex legal ecosystem keeping the peace, feeding people, and making sure the guy in charge actually speaks a language.
It gives you a new appreciation for the sheer logistical miracle that is a major construction project.
Absolutely. Now, before we go, I want to leave you with a thought. We talked about the engineer's power to remove a worker for conduct prejudicial to the protection of the environment.
Right, Clause 6.9.
In an age where climate change is the central issue and ESG is dominating boardrooms, how broadly could an aggressive engineer interpret that clause?
That is a great question.
Could they remove a project manager because their logistics plan isn't carbon neutral enough? Could they police the personal consumption habits of the workforce in the name of the environment?
It's a clause that might have a lot more teeth in 2030 than it did in 2017.
A very provocative thought. As the definition of environmental protection expands,
The power of the engineer to control the contractor's personnel expands with it. It's definitely a legal frontier to watch.
well, something to think about. Thanks for diving deep with us today. We'll see you on the next one.
Goodbye.
If you're interested in the templates, please visit our shop. The link is in the description.
Thanks for watching. Please subscribe and see next time.